I thought I'd do something a bit more practical for you today, rather than just the sort of commenting on what's in the news. Because I think a lot of you know, I do quite a lot of the advocacy training for the new barristers. So we actually teach them how to conduct advocacy. Advocacy is the art of persuasion. So how do you persuade a judge or a jury? So I thought if I just share with you what we teach them, then if you ever do find yourself in the unfortunate situation of having to be in court and act for yourself, then it'll give you a few tips and ideas. And there's no great magic to it really. But one way I summarise it is this. As advocates, we have a tendency to see cases as battles to be won. But for judges, cases are problems to be solved. So you help the judge solve the problem. And what do I mean by that? Well, you make their life as easy as possible. There's lots of reasons for doing that. So I'm just checking that is actually still recording. Yes. There's lots of reasons for doing that. I mean, judges these days, they're very, very busy people. So they don't have time to read into cases and prepare things. A lot of the time it'll be like, you'll be sat there waiting, there'll be a long list, and as soon as a court becomes available, it might be, okay, you're in front of Judge X, who's just being given the papers. Also, generally speaking, while judges will always try the cases on the law and the facts and the merits, it doesn't exactly, I'm not saying that, being nice and the judge liking you will make you win your case, but annoying the judge and making their life hard certainly won't help you win the case. So what do you need to do? We have this idea that 95% of cases try themselves. If you can actually get all the material in front of a judge can see very quickly, what the issue at hand is and have a very good view as to what the result should be. So a lot of the time, it's not actually about using your fantastic persuasive skills and your wonderful, devastating cross-examination. It's just a matter of making sure the judge can see the material. So what are the key things? One thing is, trim the fat, okay? Now, when you're acting for yourself, you've got a lot of emotional investment in the case, and there might be lots of things that you want to get off your chest. That's irrelevant. The judge doesn't care. The judge doesn't particularly care about all the background and the rows. You're asking the judge to make a decision on a very specific point. So excise everything that isn't on that point. So when you do your witness statements, just focus on the fact. Don't put in there that, this is about a claim where somebody tried to rip me off, and let me tell you, he's a bad one anyway. And also, this is why we should win, because all the evidence is our favour. A witness statement is literally just a set of facts. In your own words, you don't quote law and you don't make legal arguments in there. You do that later on. So keep your witness statements really simple. Test them out by just giving them to a friend who knows nothing about the case and saying, do you understand what's going on here? Set them out. One fact per paragraph. Paragraph 1, my name is blah, 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 and I live here. Paragraph 2, this is a dispute about, a building contract. Paragraph 3, we instructed the defendants to build us a kitchen extension. Paragraph 4, they turned up, they made a really bad job of it. It should be one fact per paragraph. So, this is where you start winning your case, by getting all your preparation there. Make sure all your documents are in order. You'll prepare like a bundle. That's like, the case file that the judge gets to read. Make it really obvious where to find things and stuff. Paginate it, have an index, have big page numbers, get your felt tip marker out and write, 1 big circle around it, 2 big circle. There's a thing that we talk about in the law called Sedley's Rules of Documents, which now Lord Justice Sedley, he just prepared it. It's like a sort of sarcastic list of rules about how documents should be prepared, and it's all things like, at least 10% of the document should appear more than once in the bundle, at least 5% of them should be photocopied upside down. It's all things like that, but that expresses the frustration of judges. So you make it really simple. Then when you get into court, you always say to people, say who you are, what you want, why we should get it. May it please the court, my name is, I'm the claimant in this matter, the defendants are so and so. What we want is, we want damages for a breach of contract or for negligence or something like that. And the reason we should get it is the following, because you'll be hearing about how we instructed these people and they made a complete mess of it. And point them to the evidence. When it comes to dealing with witnesses, again, keep it simple. I know emotions run high, but you need to be really, really objective about this. When it comes in civil proceedings, it's all done on witness statements now in what we call examination in chief. So you don't actually orally tell your side of it. You just sit there and it'll be, here's my witness statement. If you have a lawyer, they'll say, turn to page 10 of the bundle. Is that your witness statement? Right, turn to page 13 of the bundle. Is that your signature where you say it's all true? Yeah. Is it all true? Yep. Okay, wait there may be some questions. If you're self-repping, you'll literally say, here's my witness statement. But then each side gets to cross-examine. And there's two purposes to cross-examination. First of all, you have to put your case. If you are going to say that somebody is wrong about something, then you have to give them an opportunity to comment on that. So, you say here that actually we agreed to do X, Y and Z, but really we agreed to do A, B and C. Now remember, you're not trying to persuade the witness. It's the judge you're trying to persuade. It's not like Perry Mason where people do suddenly crack and get you, oh yes, you're right, it was me all along. Having said that, we always say it's cross-examination, it's not examining crossly. And if you are gentle with people, and you ask reasonable questions and you're not argumentative, it's amazing what people will agree with. I mean, one thing I do in cross-examination actually is I always start by saying, okay, first of all, let's see what we can agree on. And I'll be very gentle and I'll just go through things that, aren't necessarily in dispute. And then you lead people, you paint them into a corner. Because if you can ask a series of reasonable questions, and remember, the cliche, you never ask a question you don't know the answer to, so you know what they're going to say. But if you can get a series of logical questions that lead up to one conclusion, and then you put your fatal killer question, so having said all that, isn't it the case that X, we win? Well, they can either agree with you, in which case you've won, or they can disagree with you, in which case you just roll your eyes, raise an eyebrow and go, well, because it just makes them look daft, because you've led them to that sort of logical position. But like I say, sometimes, especially where it's not the parties themselves, it's just witness called on behalf of parties. I mean, people take the oath very seriously. People, usually don't like to be perjuring themselves. And you should always tell your witnesses, even your own witnesses, just answer the truth. Just tell the truth. Do not try to help me. There's nothing worse than a witness who's actively, clearly trying to help you. Because judges can smell that a mile away, and they just lack credibility. Because it's like, well, you're clearly here just to support one side or the other. You're not here to tell me the objective truth. So brief your witnesses. Don't tell them what to say, but tell them, that they should always just, speak the truth and be honest about it. And, if you've done an assessment of your case and you've looked at it, and you come to the conclusion, well, actually, if this evidence comes out, maybe my case isn't as strong as I thought, maybe that's the time to be sitting down with and having a think about settlement. I mean, that's what lawyers do all the time, and that's why 97% of issued claims settle, because we get all the material and go, right, well, we can pretty much see we can all see what's going to happen here. We don't need to bother with the trial. But that's just a few tips. I mean, patience is another one. When you're in court, everybody, there's a sort of a structure and a timetable. People get to tell their side of the story, then people get to question that side of the story, then you get to make speeches. Don't be jumping in, don't be interrupting, wait your turn. There's nothing worse than, you interrupting the proceedings by saying, that's not true, when the people are giving evidence or something like that. Wait until it is your turn. Also, don't use, questions are for asking questions, they're not for giving evidence. Okay, so you are asking questions, you are not giving your own evidence while you're asking questions, and you're certainly not making speeches. I mean, this is something we tell the young barristers. The purpose of cross-examination is to elicit information. It is not to make arguments. You save that to the end. But yeah, once you've got all that out, and like I say, sometimes it can be really good to produce like a document for the judge. Produce a chronology. That's always a great thing because judges come to this blind. So just here's a list of key dates and key things. And try and agree it with the other side. Say, do you agree this is, the history of this? Do a list of the issues, dear judge. Here's what's not in dispute. Here's what's agreed between the parties. Here's what is in dispute, and here's what you need to make a decision on. And like I say, the mere fact that lots of things are in dispute, that might not be relevant to the issue at hand. So you can say to a judge, look, there's a lot here that is in dispute, but very little of it actually goes to the decision you need to make. So I hope I'll be forgiven if I don't put every point to every witness. And judges will usually say, oh yes, thank you, please do that, because they don't want to be bogged down with irrelevant stuff. So I keep coming back to this. Anything, trim the fat. Also, being there, one question you should always ask yourself and be able to answer is, what am I actually seeking to achieve here? Now, on a strategic level, it could be, well, I'm here to, succeed in this claim, or I'm here to defend this claim. Could even be just something like, I'm here to get some directions that we can all leave and agree with. But when it comes to a tactical level, what am I trying to get out of this witness? What do I need? What points do I need to make in my cross-examination? Because a lot of the time, like I say, you need very little bits, bits of the material. I mean, a lot of the time you can find the material from things that aren't in dispute, like contemporaneous documents, emails at the time. And judges like that. I mean, I'm not saying judges ignore witness evidence, but judges are very aware that what people are saying now, a couple of years later, where, they're probably remembering things as best they can, but memory is reconstruction, not recall. So perhaps people are now remembering things how they thought it went, how they wish it had gone. Whereas judges, basically, they know that emails that were sent between the parties before anybody realised there was going to be a row, they're more likely to contain, they're more likely to be an accurate description of the situation than anything now 2 years later when you've all fallen out about it. So try to use that. When you're giving evidence and stuff, say, well, you'll notice that my witness said X, Y, and Z, and this is consistent with the email that was written 4 years ago. Therefore, that may make you think that if they're right about that, they're right about everything else. And you can also use it against. You can say, well, my opponent is now saying this, but if we look back, there was a letter sent at the time that's completely contradictory to this. I'm not suggesting they're lying or anything, but it may be that their memory now isn't as accurate as when they wrote this letter 4 years ago. So anything that's inconsistent with that, I invite you to ignore, and I invite you just generally to take that into account when assessing their credibility. But there you go. I mean, I can do more about this, but that's, there isn't any great magic to this. Like I say, it's just a matter of making the job of the judge very easy. I mean, field test this, literally, go down the pub or a coffee shop and just run your arguments with a mate who doesn't know anything about it and see if they grasp it. I mean, one judge said to me, he said, explain everything to me as if it was the night before the trial, we're in the pub, I'm sort of interested in what you're saying, but I'm also trying to watch the football. So there you go. Anyway, as always, hope you found that vaguely useful, vaguely interesting, occasionally accurate. Oh yeah, like, subscribe, share if you did, and all that sort of thing. Where am I today? I'm at Pentyre, near Newquay. Pentyre means headland, and interestingly, so does Kintyre, because there are two types of Celtic, Brythonic and Godelic, or P&Q Celtic as they call them. And it's all to do, one of the big differences is whether they begin words with P or K and things, and Kintyre and Pentyre, both meaning headland. Are two examples. So down in Cornwall, we use the P as they do across in like places like Brittany, whereas up in Scotland and Ireland and places like that, they use the K sound. So there you go. That was a bit of a diversion, but you know I like to ramble.